Welcome to the fifth section of our course, focusing on investigation, compliance, and enforcement. In this lesson, you will learn exactly what to do when things go wrong and a privacy incident actually happens. This topic is incredibly important, because even the best security programs experience failures. And how you respond determines the financial and legal survival of your organization. I am going to walk you through the entire incident response lifecycle, from the initial investigation to reporting the breach to the federal government. Get ready to master the high-stakes world of regulatory compliance and enforcement, because these scenarios are heavily tested on your exam. To ensure you are fully prepared, I highly recommend obtaining the practice tests or our offline app, both of which are fantastic tools for testing your knowledge of these critical procedures. The first step in this process is understanding the difference between a security incident and a data breach. A security incident is the attempted or successful unauthorized access, use, disclosure, modification, or destruction of information. A breach is a specific type of incident that involves the impermissible use or disclosure of protected health information that compromises its security or privacy. Every breach is a security incident, but not every security incident is a breach. The exam will expect you to recognize that an incident is the broad term for a security event, while a breach has strict legal definitions and reporting requirements attached to it. Because incidents happen without warning, your organization must have an incident response plan fully prepared in advance. This plan is a detailed, step-by-step guidebook that tells your staff exactly what to do the moment a security event is discovered. It designates who to call, how to contain the damage, and how to preserve critical digital evidence. For the CHPS exam, you must remember that an incident response plan is a required administrative safeguard under the HIPAA security rule. Trying to invent a response strategy in the middle of a massive cyber attack is a guaranteed recipe for a compliance disaster. To execute that plan, your organization needs an incident response team. This is a specialized group of experts ready to spring into action when an emergency strikes. The team typically includes the privacy officer, the security officer, IT professionals, legal counsel, and human resources representatives. Bringing all these different perspectives together ensures that the organization handles the technical, legal, and personnel aspects of the incident simultaneously. Exam scenarios will often test your knowledge of who should be sitting at the table during a major security crisis. When an incident is discovered, the absolute first priority of the response team is containment. Containment means stopping the bleeding and preventing the incident from getting any worse. If a hacker has compromised a specific server, containment might involve physically unplugging that server from the hospital network to stop the virus from spreading. You must understand for the exam that before you can investigate who caused the problem or calculate how much data was lost, you must immediately secure the environment to protect the remaining patient information. Once the threat is contained, the privacy and security offices begin a formal investigation to uncover the facts. The goal of the investigation is to determine exactly what happened, when it happened, who was involved, and what specific data was compromised. This process heavily relies on reviewing the electronic audit logs we discussed in the previous section. Exam questions will test your understanding that a thorough, objective investigation must be conducted before any assumptions are made or any breach notifications are sent out. If the investigation reveals that protected health information was inappropriately accessed or disclosed, you must perform a formal breach risk assessment. This is a highly testable, 4-factor test used to determine if a legal breach has actually occurred. The legal presumption is that any unauthorized disclosure is a breach, unless you can prove there is a low probability that the data has been compromised. The exam will demand that you know this standard perfectly, as it shifts the burden of proof entirely onto the healthcare organization. To get comfortable applying this 4-factor test to real-world scenarios, utilizing the practice tests or our offline app is a highly effective way to study and test your judgment. The first factor of the breach risk assessment examines the nature and extent of the protected health information involved. You must evaluate the types of data that were exposed, and the likelihood that the information could be used to re-identify the patient. Losing a list of patient names and social security numbers creates a massive risk for identity theft. On the other hand, losing a completely de-identified list of medical conditions poses a very low risk to the patients. The second factor looks at the unauthorized person who used the protected health information, or to whom the disclosure was made. You must ask who received the data. If a nurse accidentally faxes a patient chart to another doctor's office, the risk is relatively low because the receiving doctor is also bound by HIPAA privacy rules. However, if that same chart is accidentally faxed to a local grocery store, the risk is incredibly high because the store employees have no legal obligation to protect the information. The third factor of the assessment determines whether the protected health information was actually acquired or viewed. Just because data was exposed does not necessarily mean anyone looked at it. For example, if an encrypted laptop is stolen, or if a hacker breached a server but the audit logs prove they only looked at an empty folder, the data was not actually acquired. The CHPS exam will test your ability to use forensic evidence to prove whether unauthorized eyes actually saw the sensitive patient data. The fourth and final factor evaluates the extent to which the risk to the protected health information has been mitigated. Mitigation means taking immediate steps to lessen the potential harm caused by the incident. If an employee accidentally sends a spreadsheet of patient data to the wrong email address, but immediately calls the recipient and gets them to permanently delete the email before opening it, the risk has been heavily mitigated. Exam questions frequently use mitigation scenarios to test your judgment on whether a full breach notification is required. If the risk assessment determines that a breach has occurred, the HIPAA breach notification rule kicks in immediately. The most important timeline you need to memorize for the exam is 60 days. A covered entity must notify affected individuals without unreasonable delay, and in no case later than 60 days following the discovery of a breach. Discovery happens the moment any employee in the organization becomes aware of the incident. Exam questions love to try and trick you with this timeline. So remember that 60 days is the absolute maximum legal limit. The size of the breach dictates who else needs to be notified. And the magic number for the exam is 500. If a breach affects 500 or more individuals, it is considered a major breach. You must notify the Secretary of Health and Human Services immediately. At the same time, you notify the patients. Furthermore, you must also issue a press release to prominent media outlets serving the state or jurisdiction where the patients live. High-profile breaches make the evening news because federal law explicitly requires it. If a breach affects fewer than 500 individuals, it is considered a minor breach. For these smaller incidents, you must still notify the affected patients within the 60-day window. However, you do not need to notify the federal government or the local media immediately. Instead, you keep a log of all minor breaches that occur throughout the year, and submit that entire log to the Secretary of Health and Human Services within 60 days of the end of the calendar year. The government agency responsible for enforcing these rules is the Office for Civil Rights, or OCR, which falls under the Department of Health and Human Services. The OCR is the federal watchdog for healthcare privacy, and they have the power to investigate complaints, conduct compliance audits, and issue massive financial penalties. Whenever you see a question about federal investigations, federal fines, or HIPAA enforcement, the correct answer is almost always the Office for Civil Rights. When the OCR issues financial penalties, they follow the HIPAA enforcement rule, which establishes a tiered penalty structure based on the organization's level of culpability. The lowest tier is for organizations that did not know a violation occurred despite exercising reasonable diligence. The highest tier is for organizations that committed violations due to willful neglect and then failed to correct the problem. For your exam, you must understand that the fines increase dramatically, potentially reaching millions of dollars, if the government proves you willfully ignored the law, instead of just issuing fines. The OCR frequently requires organizations to enter into a resolution agreement and a corrective action plan. A corrective action plan, or CAP, is a strict, multi-year contract where the hospital agrees to completely overhaul its security program under the close supervision of the federal government. This usually involves mandatory outside audits, forced policy rewrites, and extensive new training requirements. The exam will test your understanding that a CAP is a severe enforcement tool used to force long-term compliance on a failing organization. It is also crucial to know that the federal government is not the only entity that can punish you for HIPAA violation. State attorneys general also have the legal authority to bring civil actions against individuals or organizations that violate HIPAA on behalf of the residents of their state. This means a hospital that suffers a data breach could face a massive federal investigation from the OCR, followed immediately by a massive state lawsuit from their local attorney general. The best defense during an OCR investigation is a perfect paper trail. Investigators will demand to see your risk assessments, your training logs, your policies, and the documentation of your internal breach investigation. If you properly documented all your compliance efforts, the OCR is much more likely to show leniency. The CHPS exam will continually reinforce the idea that in the world of compliance and enforcement, documentation is not just paperwork. It is your primary legal shield against devastating financial penalties. Congratulations on completing the 5th section of this course. You have now mastered the high-stakes procedures for investigating security incidents, reporting data breaches, and navigating federal enforcement. Now, I strongly encourage you to obtain the attached practice tests or the offline app to apply what you have just learned. Working through these practice questions will improve your retention and get your brain perfectly tuned for the actual certification exam. Remember that these educational tools are included right here with this lesson. So please dive in and keep up your active learning. End this session with a positive mindset. And I will see you in our final section covering advanced scenarios.